Hello, everybody, and welcome to Estate Planning 101. I'm excited to be here today. My name is Laura Akins. I'm sharing my screen already, so I hope you can see the first slide of our presentation today. This is Nadler Biernath, the firm on the front, so you can kind of see all of our faces. A little disclaimer before we get started. All the information that I'm giving you today is for educational purposes only, should not be construed as legal advice. You should talk to a lawyer directly to get legal advice. But hopefully I'll give you a lot of really good information, and certainly we'll be able to ask questions and all that kind of thing. So my name, like I said, is Laura Akins. I'm with Nadler Biernath. We are a full service estate planning and probate firm with a specialty in elder law and special needs planning. And so in the midst of COVID and all of the craziness that we've been going through, we've decided that people have a lot of questions about estate planning and what we're doing here. And in a way to kind of get back to clients and also just provide some good information, the attorneys at Nadler Biernath are going to be doing a series of virtual presentations we're calling Planning for Peace of Mind, with the idea that getting all of this stuff out there, kind of figuring out what you need to do is a weight off your shoulders, you know? So today we're going to be talking about the basics of estate planning. On Thursday, September 24th, we'll have our next presentation. Heather Nadler will be discussing financing long-term care. And so that's going to build on our presentation today. That's going to be really important for folks who maybe you're caring for aging parents, or those of you who are in fact aging, and maybe you're looking at retirement, or you're into retirement and thinking about how do you want to make sure that you're covered in the event you require long-term care, which of course we all understand now is quite expensive, and we don't want to necessarily drain all our resources if we don't have to. So again, that'll be September 24th, but today we're talking about estate planning. A little about me here. I'm not going to read through all of this. Again, Laura Akins, I'm an Atlanta native. I love doing the estate planning work that we do because we get to meet with so many different types of clients. I feel like we're always engaging with the community in this really kind of nice way, because we can help people and connect on a personal level, and hopefully, again, kind of take a weight off your shoulders and make everybody feel good about their planning and preparation. All right, so let's kind of get into it. We're talking today about the basics, and this conversation is going to be something where if you're doing your initial planning, or maybe you did some planning 10 or 15 years ago and you're coming back to it, these are the types of things that you're going to want to go over either on your own or with an attorney when you're doing estate planning. As we go along, if you have questions, please ask them. You can do that in the Q&A box. So there's a Q&A icon at the bottom of the screen. Typically it's at the bottom of the screen. It's at the bottom of my screen. And you can put your question in there. I'll try to answer them. I'm just going to kind of pay attention, and I'll try to answer them as we go along. But if I don't get to all of your questions, we'll also have time at the end. And of course, we're available via email, so we can make sure that you have that information. Okay, so when you're first going to your initial conference with your lawyer, or maybe you're thinking, what do I need to do? What kinds of documents do I need to do to cover my estate planning? This list on this slide is it. So you need to make sure that you've looked at your financial and your healthcare powers of attorney, how your assets are titled. Maybe they're not titled the way you actually want them to be based on your estate planning goals. Maybe they are, and then that's perfect, and you know that, and you can move on, right? We're also going to look at beneficiary designations, which we'll talk about all of these things in a minute. Beneficiary designations have become very important because we have a lot of money in accounts that are beneficiary designated nowadays. Of course, we also want to look at a will. That's almost always going to be part of the conversation. And then trusts we have on here, and I'll briefly touch on today. Sometimes trusts are a great choice for people. They just, their needs are such that trust planning is really important. Other times in Georgia, it doesn't matter so much. That also is, I'm glad that I mentioned that, put it top of mind here. This is all Georgia specific advice and information. Georgia law directs how we do powers of attorney and how we do estate planning. And so if you're in Georgia, but you're planning to move to another state in, 6 months or 3 months, then you probably should wait until you move to the other state to do estate planning. If you do documents in Georgia, and then you move to another state in 3 years, you would want an estate planning attorney to review those documents. Make sure that they are viable in that state and make sure that you aren't going to have any issues. Likewise, if you've done other documents in another state and then you've moved to Georgia and you plan to be here long term, you would very much want to make sure those documents are good in Georgia. Sometimes, almost always, existing documents will work, but they may not be perfect in such a way that it'll be very expensive. It could be complicated. It could be time consuming, and you can avoid a lot of that by just running them by an attorney. So it's something to think about. Okay, so these are all the different things. If you go to a lawyer, they should bring all of these things up with you. The first and kind of most important thing is when we talk about planning for incapacity. So this is while you're still alive, but you're unable to make your own decisions. This is because you are in a car accident and you're in the hospital and you are not able to vocalize. This is because you have had a disaster type of accident where you get kicked in the head by a horse and you have a traumatic brain injury, and your parents need to figure out how to get workers' compensation paid to you. These are real life examples, okay? So things happen, and incapacity can cause a lot of issues for other folks dealing with your business, even if it's not, you're in a situation where your financial circumstances aren't complicated. They still exist. Once we turn 18, most of us have a bank account, most of us are working, and that creates some complications that you should plan for. Without planning, if you become incapacitated and there are issues, if your family doesn't agree, if the doctors and your family disagree, sometimes just to get access to a bank account, you have to get a court-appointed person that's a guardian or conservator to deal with this stuff. That's a complicated process. You have to have a court hearing, there's court filings, and so we want to avoid that if we can. Okay, so that we break these two things into two separate categories when we're talking about incapacity. And the first is healthcare. So we have in Georgia something called the Advanced Directive for Healthcare. The Advanced Directive is one form that combines both the agent choice, so choosing a healthcare agent to make decisions if you're unable to make them yourself, and it combines that living will decision of how do you want your end-of-life care to be. So we used to break those two choices out, and now we combine them together. And the Advanced Directive for Healthcare is a pretty ubiquitous kind of universal form in Georgia. It's not something you have to talk to a lawyer to do, but sometimes to fill it out properly or to make sure you know what you're doing and how much power you're giving to someone, it's important to consider kind of the legal ramifications of doing it wrong. This is the kind of Terry Schiavo situation where she was, for those of you that remember, she was in an accident and had some issues that created so that she was in a vegetative state, and her husband disagreed about her care with her family, and she didn't have any documents, and so it was kind of up to the doctors, but the family was pushing back against her husband and the doctors, and so a very lengthy and expensive court battle ensued. And then they finally pulled her off life support. Of course, nobody wants to think about that, right? That's not fun, but it can happen. And a lot of people I hear say, oh, well, my husband just automatically has that power, so it's fine. But if you don't put it in writing, then yes, your spouse would be the default person to make these choices. But if your family disagrees and it's not in writing anywhere, then we have issues. Likewise, a lot of people who are single, their parents would be the default agents. And sometimes people don't want their parents to be making those choices. You know, maybe mom is a little bit sensitive, or maybe dad is just, you know, not interested in having that authority, or maybe you don't have a good relationship with your parents. You know, I mean, these are things that you can think about and choose, and it can make a big difference in how you receive care. So this is an important document. The other power of attorney document that we do is the financial power of attorney. And you can have a power of attorney for finances related to kind of a specific thing. So if you close on a real property, you can have a financial power of attorney specifically for that transaction. Or you can have a general, what we call a durable power of attorney that exists over all the different topics related to your financial situation. In Georgia, as of 2017, we have a new financial power of attorney form. So we've got a lot of clients coming in with older documents, or maybe documents that they found online, but they don't align with the new statutory form. And that'll be something that you should make sure that you have updated, because the new statutory form has some infrastructure in the law that requires banks to accept the form. That can be important because banks are very worried about liability. All these financial institutions in general are worried about liability, and they want to know that if they're using a financial power of attorney, the bank is not going to be subject to liability. So they can actually say, no, we don't want to use it. We're not going to accept that financial power of attorney. And this Georgia form is one that under the law, again, if you have the right form, banks are required to accept it. So that's kind of important. A financial power of attorney can be a springing power of attorney, or it can be effective immediately. A lot of people ask us about this springing power of attorney, and what that means is they don't say, hey, what's a springing power of attorney? But what they say is, can I have a power of attorney that only comes into effect upon my incapacity or upon some event? And that's the idea behind the springing power of attorney, is that the document will only come into effect and only give your agent the power to make financial decisions on your behalf in the event of something, whatever it is, we can specify in the power of attorney. I actually don't like doing these springing financial powers of attorney, and I typically discourage clients from doing them, because you need your financial power of attorney when you're in crisis. So if you were in that car accident and you're in the hospital, you're not planning to get in a car accident, right? You're not planning to get hit in the head by a horse, right? But things happen, and so if the document is only effective upon some event, then we have to certify that the event has happened before the power of attorney is valid. And that certification process can kind of make the document a little bit moot. So it's important to consider that and make sure that, you know, you're not overthinking things. You're not choosing people that you don't trust and maybe hoping that you'll mitigate some of those issues by having the springing power of attorney, and instead just putting folks in right away as your agent that you know will do the right thing. Again, both the healthcare advance directive and the financial power of attorney are only active while you're in life, but you're incapacitated, okay? So who needs these documents? And the answer is everybody over the age of 18. Definitely couples who are not legally married. If you want your partner who's not your legal spouse to be able to make these decisions, this is a critical document to have. because they do not have any authority under the law otherwise. People with joint accounts, or people without joint accounts, that's going to be another important thing. If you're married, or maybe you're working with an older parent and you have a joint account, a joint bank account, that can be, we'll talk about that in a minute, but joint accounts are a little bit easier to work with when you've got two people on there. But if you're married, and you and your spouse have separate accounts, or if you have a parent or somebody else who you are helping, but you aren't on their account, then you really need this. I still think even if you have joint accounts, this is helpful because it's kind of a backstop if you have issues with the bank. But nonetheless, these are some specific things. Again, without these documents, I can't really say it enough because it's important to understand. Court intervention is required if you need some assistance with any amount of money. And we can even be talking about $2,000 here. We can be talking about a bank account that holds $2,000 that you need to get access to pay bills. And if the person is in a coma that owns that bank account, there's no way to get to that money. So this is important. When we're thinking about who is the best person to serve as your agent under a financial power of attorney or advanced directive for healthcare, those can be the same people. You can have the same agent for healthcare decisions and financial decisions. They can also be separate, and sometimes it's not the worst idea to have them be separate. A financial agent is going to be someone who is, of course, trustworthy, responsible with money, knows when to ask questions. I always call it kind of business common sense. They know how to take care of business, but they also know when they have reached their maximum capacity of understanding and they need to reach out to a CPA or a lawyer or whoever. And the healthcare agent, also, of course, you want to be trustworthy, but that's a pretty heavy job, because if you think about it, they're going to be helping you make potentially end-of-life decisions. And when you think about that, you know, I had a couple pre-COVID who was signing in my office. They were signing their documents. And the husband looked over at the wife and said, "Are you sure you're the right person to serve as my healthcare agent?" Because he didn't feel like she was going to be able to carry through with his decisions because she loved him so much, which is really nice. But it's also just something to consider. You know, do you want your spouse to be the person to make that decision, or maybe we put that on another person? We just had a couple questions come in. The first one on abuse of a financial power of attorney. I do have referrals to that, but what I'll ask that person is to send an email to our office, and we're happy to give out referrals for those things. The second question is, does guardianship take place of a power of attorney? And that's a great question. It says, is power of attorney required in addition to guardian and conservator? So first of all, power of attorney is not required in addition. So oftentimes we see a situation where a person has no power of attorney, but they need someone to make decisions about their finances or their healthcare. And so when you're in that situation where you have no existing documents, but you need business to be taken care of, that's when we oftentimes have to file for guardianship or conservatorship. So in that case, we have no power of attorney. Typically though, the guardianship and conservatorship supersedes the power of attorney. There's some caveats to that, and that gets a little bit more complicated, but by and large, in cases where there's not any kind of issues or contest over who's going to serve, that's when the guardianship and conservatorship will supersede the power of attorney. So another participant said the best advice for advanced directives is to make as many decisions in advance as possible from a medical professional. And I totally agree with you. That's a great point. So having all of this stuff on paper ahead of time just makes everything so much simpler for everyone involved, certainly for the hospital staff, the doctors, and your family. And that's why we kind of encourage people to think about these really tough things. It's not really fun or pleasant to think about end of life, but but we're humans and things happen. So important stuff to think about. Okay, so then we get to that. So we just kind of talked about incapacity. Now we want to talk a little bit about what happens when you pass away. What do we do with the assets that you have? How does that look for folks that have various different types of assets? And as we're meeting with clients, we always ask people to provide a list of what assets they have. And really what we're looking for there is what kind of asset is it? Is it a retirement account? Is it a bank account? How is the asset titled, and approximately how much is in there? The amount is a little bit less important these days, though that's still relevant. But the main thing is understanding how this stuff is going to transfer when someone passes away. In general, as a rule, you can only control assets that you own, which may sound like common sense, but it's not. Sometimes, like we were talking about with joint bank accounts, different assets will pass by operation of law because of the way they're titled. So what that means is that if you have a joint bank account with two people on the account, when one person passes away, that surviving owner now owns the bank account by operation of law, because that's just the way the law dictates joint bank accounts. That's not the case with real property. So with residential property and other things like that. So it does depend a little bit on what kind of asset we're talking about when we have operation of law. If a deed does say that you own the property, if John and Jane own the property with right of survivorship, if that right of survivorship language is on the deed, that's also by operation of law, the survivor of John and Jane would be the sole owner. So those things pass automatically. We don't look at the will. We don't look at any other documents. We don't have to file anything with the court. So it's very important to understand that when you have a joint account, it's going to go to the surviving person. We have a lot of clients who have joint accounts with kids because they want the kids to be able to help them with the money. But they don't realize maybe you've got two kids. One of them's really responsible, really good. The other kid is also a lovely child. He's perfect, except for that he's terrible with money. So we don't want to put him on the bank account. That doesn't mean we want to exclude him from the money, you know? So we don't necessarily want all of the money that's on the joint account to go to that first son who's so trustworthy and great with money and totally exclude the second son. So it's just important to understand how things pass. Likewise, with beneficiary designations, that's really important to understand. Insurance, life insurance, all retirement accounts are going to have beneficiary designations that you can make. And once you make those designations, they pass to those people outside of the will. We don't look at the will. We don't look at any other documents. That's why we have on there beneficiary designations trump a will. And this is really critical because nowadays, most of us are accruing most of our savings in retirement accounts. No matter how much money you actually have in your retirement accounts, whether it's a little or a lot, this is where most of us are accruing the bulk of our savings. And so it's very important to stay on top of those beneficiary designations. For a person who is recently married, you might have had your parents on your retirement account as the beneficiary designated person. Maybe you want to update to your spouse. Maybe you don't, I don't know, but that's something to consider, right? Likewise, if you were married and then your spouse, you and your spouse divorce, or maybe your spouse passes away, we don't want to leave the spouse on there as the beneficiary designation. So those are kind of important things to understand because we don't even look at the will when we're looking at those assets. And oftentimes, a lot of folks have a lot of those assets in those types of accounts. However, we're not going to say forget about the will because the will is kind of a catch-all, pretty important protection. The will is going to direct whatever assets are just in your name. So if you have real property that's just in your name, if you have checking accounts that are just in your name, if you have other, business assets like an LLC or something like that that doesn't have any kind of other planning associated with it, that could be caught by the will. The will also does some really important functions of appointing an executor, which is a personal representative of your estate, your business, after you pass away. And then you can also appoint a guardian if you have minor children. And in the event that you needed a trust, we could put that into the will, a trust, and then we could put the trustee in there. I think it's quite important that people kind of understand a little bit about Georgia probate in thinking about avoiding probate. It's something that we hear all the time now. We want to avoid probate. And that's a fair point. And we'll talk in a little bit about trusts. And I'm just going to briefly touch on it. But just in general, understanding how probate works in Georgia is usually kind of a relief for people, because then they realize they don't necessarily have to worry so much about avoiding it. Before I talk about that, I just want to briefly scan the questions and make sure I have some folks giving me some kudos, and that's so nice. And so somebody asked, does operation of law or beneficiary designations control ERISA accounts? And so ERISA accounts are, it'll depend on whether or not, it wouldn't be operation of law, right? So operation of law is going to be if it's titled in a certain way where there's two people on the account. But it could be a beneficiary designated account, and very, very likely you could have a beneficiary designated account. That would be something probably to talk to your HR representative about, but very likely that would have a beneficiary designation on there. Well, there are a couple other questions about advance directives and guardianship and powers of attorney. I'll come back to those at the end since we've kind of moved on from that. Okay, so let's talk briefly about how a will works in practicality when you pass away. So if you have assets in your name in Georgia, you have to get them out of your name, right? And so when you pass away, even though you have passed away, your asset lives on, and you have to transfer it out of your name. And so the way we do that is we file a petition to probate in the county in which you were living and intended to reside upon your death. We call that your domicile. And after you file that petition, you do have to notify a deceased person's heirs, and you go through that process. The cost is at a minimum about $150 for filing fee, $150 to $250. That depends a little bit on the county and other things, but at a minimum, it's about that much money. If you hire an attorney, it can be a little bit more, but it's not expensive, right? And so you go through the process of filing the petition to probate. The court will review the petition and review the will, and the court will determine if the validity, I don't know why I put that in quotes, they're not determining, they are determining, but they're determining the validity of the will. The probate process is about proving that the will was executed properly and that it's a valid document. Assuming that the court finds that the will is good to go, they will then appoint the executor by a document called letters testamentary, and then the executor goes about their business. A relatively simple kind of probate process takes somewhere in the range of 1 to 3 months or so, and then you have to go about transferring assets. But it's not terribly expensive or terribly complicated. That's unlike places like New York, California, very, very complicated laws there, not the case in Georgia. Somebody asked, is the executor the one who files probate? And the executor typically is the person who files for probate, but not necessarily. Somebody else asked, does the slide need to change? And no, I'm just chatting through here. We'll get to the next slide in just a minute. But so I just wanted to give a brief a summary of probate, so you understand that it's not necessarily something to be afraid of. If you're in Georgia, it's relatively simple. And so when you've got a will, that's, again, going to control assets that you have in your name. And so, of course, things are going to change throughout your life, right? So you may have minor children. Maybe you get divorced and you get remarried. And all of those things are going to affect your will. So the will is not something that we just write and then we say, okay, perfect, you're done forever. Instead, we say, okay, maybe, in my dream world, I'd have clients reviewing their will on their own once a year or so, and thinking about what things have changed in their lives. Have they moved to another state? Have they had more children? Have they, had a death in who they've, let's say you've appointed someone as executor and that person has passed away. We probably need to make some changes so that you have updated designations. Somebody asked if I can speak to families with children from previous marriages. And that's a perfect example of why you should do some estate planning. We have lots of folks with mixed families nowadays, stepchildren, step-parents, and a will is going to be a really great way to organize all of your assets. If you're married to someone who has children from a previous marriage, that person may want to make sure that they do some extra planning so that their children from the previous marriage don't get, the shaft. They don't get left nothing because you don't do any planning. I think it's also really important in kind of slightly more complicated cases like that to do a will, because then you can appoint the executor. So you appoint someone who has the legal authority to take care of business and handle all of the things that need to happen. And while there may be a little bit of like, well, I don't know about that person, you've at least given someone that legal authority. And so there's more clarity about how to take care of business in that case. We can do all kinds of things in a will to make sure that there's equity when we've got, maybe a new spouse, or we have stepchildren and natural born children. We can plan for making sure that, if folks are adopting their kids, or if they're doing in vitro and some of these other options that are, very common these days. We can incorporate language in there so that we cover all of our bases, and that's the beauty of having a will. Okay, and so then the other thing to kind of point out is, how do you revoke a will? Once you've got one, you've got one, and it's important to make sure that you're paying attention. Let's say that you decide you really hate the plan that you've got in the will. You would then want to do some changes to your planning, and you would want to sign a new will, and we would want to make sure that we revoke the old one. You can also actively destroy your will, and so that would literally be something like burning it, or otherwise trying to tear it up. It'd have to be totally destroyed, and you'd want to make sure that if you send any copies out, they were also destroyed. How do you amend a will? This is another question we get often about how to update your documents. Let's say that you don't necessarily want to totally get rid of the existing will that you have, but you have changes to make. The old way of doing things was through a codicil, which is called the kind of old-fashioned way of saying a formal amendment to your will. A codicil is a second document that you have. You should have a lawyer draft, because it can get a little complicated. The codicil is going to basically puzzle piece out whatever piece you want to take out of your will, and it's going to update it in the codicil. You have to formally execute a codicil, and as we've got on here, you shouldn't do this without a lawyer, because it's not as simple as just saying, I want to take this out and put another one in. I almost never do codicils anymore, because it's just as time consuming to do a codicil as it is to kind of start fresh. For clients who are pre-existing clients, we have their documents on the computer now. So as opposed to way back in the day, where we were using a typewriter to type up wills, it was pretty hard to edit, so the codicil made sense. Now we've got computers, and for existing clients, we can just go in there and update things. Of course, you can use any estate planning attorney you want, but that's a reason to establish a relationship with an estate planning attorney, because then they can go forward with you throughout life and make changes, which are almost inevitably going to be needed. Okay, and so somebody asked a question about the difference between letters testamentary and letters of administration, which is an excellent segue here. So what if you don't have a will? What happens? And in that case, you still may need a personal representative to be appointed on behalf of your estate. So whether or not you have a will, if you pass away holding any kind of assets, or maybe just having some unfinished business that needs to be attended to, you need a personal representative. And so in that case, we either are in any case, we go to the court. And so the difference between letters testamentary and letters of administration is that when you file a will for probate, the result of that, where you get a representative appointed, is the letters testamentary. When you file what we call a petition for an administrator to be appointed, that's because we don't have a will, but we need a representative, and that's when we get letters of administration. When we don't have a will, we still have to find a way to dispose of property, so we look to the law. The law gives intestate succession, and it basically rolls down your family line. So we would look at spouse and children first. This is one of the more critical points I always try to make to people, is that under the law, if you don't have a will, your spouse and children are automatically going to inherit, and it doesn't matter how old your children are. So if you've got a spouse and some minor kids, you do not want minor children to be inheriting property outright, because it's a mess. Okay, so that's a perfect example of why we need a will, because we can plan for leaving minor children funds easily. The other thing, though, is sometimes people don't have a spouse or children, and they don't love their family all that much, and they'd much rather leave things to charity, or they'd much rather leave things to friends who have become their family, you know, their friends that are family. And so you can do that in a will too. Likewise, if you're not married, but you have a partner, you can leave money to a partner in a will. The other thing is you can't choose who is going to serve as your administrator. So technically, if you don't have a will, anybody can serve. Anybody can step into that role. There's a few caveats to that. You have to get court approval and some things like that. But sometimes that can get really messy. And then the last thing, and I think something people don't understand because they don't know the legalities behind all of this, is that when you have a will appointing an executor, you're also giving your executor powers to act. You're giving your executor the ability to do things. And you don't get that when you don't have a will. So your administrator doesn't have, the power to do things expressly. So it can be much, much more expensive to be an administrator. And frankly, if worse than the expense part of it is that oftentimes you have to report to the court regularly, and that is the worst. It's a hassle, it's complicated, it's no fun, and we want to avoid that. People often ask me, believe it or not, why they shouldn't just use the forms online. Why are they paying me money? You know, which is fair, because there are so many forms online these days that you can just set up your own estate planning. And what I am happy to be able to tell people is that so far in my career, I've never had one form will that people did with some kind of form software. I haven't had one of those come across my desk that hasn't had a real flaw in it. So it's not that we can't work with the will, we usually can, but oftentimes the will doesn't provide the right powers for the executor. So we are still having to file reports with the court all the time, and that's really, really bad. Things like that happen. And then, I mean, there are always other issues as well, but some of those practicalities are are really important to understand. Somebody asked, what specifically does an executor do? And that's a good question. It's a simple answer that's really not as simple. So the executor gathers up the assets of the person who's passed away, meaning they gather up anything that's in the person's name. So beneficiary designated accounts they don't really count, and joint accounts, things that pass by right of the law, also don't count, but they gather up anything else that's in the person's name. Then once they know what they're dealing with, they pay off any debts that the person might have had or negotiate them down. And then they distribute according to the terms of the will. And so they distribute out depending on how the will reflects that distribution. It can be quite a simple job. It can be a huge job that takes a long time to finish. But the more thorough you are in your planning, the easier it gets. Okay, and so the next slide, somebody asked a person, if you die and leave kids money, what is a limit before a guardian becomes necessary? So that's kind of a good question. Let's see, oops. I've got to look, there we go, okay. So we do talk about trusts oftentimes when folks have minor children, because again, as I said, you don't want minor children inheriting money outright. It's just a mess. It's not good. So instead, we can do a trust in your will. Let me just give a little definition of a trust, and then I'll give some brief examples for when we do that, and then I'll answer the question I just said, which is, if you die and leave kids money, what's the limit before a guardian becomes necessary? So a trust is going to be a separate legal entity. We kind of look at it as a pot, right, that's ready to be filled. A trustee is going to manage whatever funds are in the trust, and the trust, as the legal entity, has a trust agreement that describes how funds are to be distributed, and it gives the trustee authority to handle all that business. So you can have a trust set up in your will so that when you pass away, the trust kicks in, and your executor distributes money to the trust, which holds money for your children. That's one example of why we would do a trust in your will. You can use trusts in lieu of wills as part of your estate planning. And that would be the case where the will would just say, hey, everything goes into the trust. But what we really hope is that before you pass away, you retitle everything in the name of the trust. So the trust would own all of your property. And when you pass away, we don't have to do probate. We don't have to mess with any of that. And instead, the trust says, here's what happens to my stuff. And the trustee would distribute. And so we do that in cases where we have a lot of out-of-state property, when people have out-of-state property, when people have complicated family situations. Like I mentioned before, when you've got stepchildren or a spouse from a second spouse, or maybe some adult kids who are a little off the rocker, or things like that. Those are some reasons why we would do trust planning. Trusts are also totally confidential, whereas when we file for probate, we have to submit the will to the court, and that all goes on public record. We very often use trusts for minor children. We also use trusts in our practice very regularly for folks with disabilities, or for folks who are aging and need some specific types of planning. There's lots of reasons to have a trust in place, but it's just not necessarily an automatic thing. When you have minor children, under 18, they have to have a guardian. That's just kind of the way it goes. But a guardian, and this goes to another question I think we had earlier. Let me kind of scroll up and look at it. So somebody was asking about, I'm not seeing it anymore. Maybe it was, maybe I made it up. But in any case, somebody was asking about the difference between a guardian and conservator. So in Georgia, we have a guardian over our health, our well-being, and we have a conservator over money. So if you don't have, as a child, if both of your parents pass away, you would need a guardian and conservator. In any case, But if you have all of the money going into a trust for your child, then maybe they don't have any money in their name, so they don't necessarily need a conservator. They would need a guardian, but then the trustee of the trust will distribute to the guardian for any needs that your child might have. So that's some planning that we can do, and they kind of align. And we can also, with the trusts for minor children, have some kind of, the right fit for your child. And we can say, oh, well, the trust distributes at these ages or these times in your child's life, things like that. Okay, and so let's see, I was going to see if there was anything else pertinent to. So somebody asked, if you're a trustee, do you need to be a conservator, right? So if you have a trust, do you need a conservator? And the answer is it totally depends on the situation. It could be the case that you also need a conservator, but it just depends. Somebody's asking, how does that differ if a child has special needs? And the answer here is that the general trust that I'm talking about would be for just a minor child. If we're talking about a minor child who also has special needs, we need a special needs trust. We can still put it in the will, although that will depend a little bit on your circumstances. We can also have a separate special needs trust that exists for the special needs child. But we would just want to tailor that trust for the minor child to be a special needs trust, and that's going to be very important. Somebody said, do these apply to disabled adults too? Again, we can absolutely do trust planning for disabled adults or children as long as they're disabled adults under 65. But we want to make sure and tailor the trust to be a special needs trust if they have disabilities. Okay, and so somebody else is asking about the trust protector, which is a great question. Maybe a little bit more in depth for this, but I'm going to answer it anyway. So in a trust, and you can set this up in a trust that comes into existence after your death or while you're living, if you've got that trust instrument that you go ahead and fund while you're alive. You can have a trustee who controls the assets. Just like the executor, the trustee is going to control assets of a trust. The executor controls the assets of an estate. The trustee would control assets and distribute. Sometimes we're worried about the trustee taking a little bit too much authority or maybe not fulfilling their duties as a trustee. And so we also appoint a trust protector. The trust protector has no authority to distribute, no authority to manage funds, but instead they have the ability to advocate for the trust beneficiary. And that can be especially important for our special needs trusts because we have a disabled beneficiary and they might really need some help in making sure that they can get what they need out of their trustee. But even for a minor child, sometimes we want to make sure that the trustee, that for a neurotypical minor child, for example, we want to make sure that the trustee is doing their job. We can put a trust protector in there also. So those are all things that we can do as part of all this planning. We can tailor all of these things to make sure that we're taking care of all of the different needs that we might have. Okay, so I am at the Q&A portion and I've got a bunch of good questions. I'm going to leave most of these specific special needs questions. Someone's asking about what happens to a special needs adult over age 65. Stay tuned because we're doing more of these presentations and we're gonna cover a lot of the special needs stuff specifically in some of those presentations. So stay tuned. Those are good questions for that. Somebody, going back to the start, somebody asked, is a power of attorney for healthcare the same as an advance directive? And the answer to that is yes and no. If you have an existing document that says power of attorney for healthcare, it's not an advance directive for healthcare. That's probably an older document that you have. If you have a document that says advance directive for healthcare at the top, then that is, in fact, it's a power of attorney for healthcare. It just also incorporates the end of life decisions. If your document doesn't say advance directive for healthcare at the top, you need to update because you have an older document, and we want to make sure that you're using the document that that hospitals, medical staff are really used to seeing, so that we don't have any issues with folks, not being able to get things taken care of. Somebody asked, does a hospital honor, I think what somebody said, an HCD in an emergency. I'm not sure what a healthcare directive maybe. What about a DNR? And so I wish I had a better answer for this. The advanced directive is still a very evolving document in that it's all up to the hospital. It's really up to the doctor to decide how to treat you. So frankly, it's important to have these documents, and it's important to file them with certainly with a primary care doctor. If you're going in for a surgery, going to be really important to file it with the doctor then. If you have a family member who's in a nursing home, it'll be very important to file it with the nursing home or the assisted living. Likewise, if you have a DNR, very important to file those, because doctors, of course, in an emergency are almost definitely going to treat somebody. That's just the way our healthcare system works. But if you've got that and you've got the agent there saying, stop, 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 sometimes you can kind of mitigate things that way. Okay, somebody asked about what bills can be paid before an executor gets letters testamentary. And that's, again, kind of an it depends answer a little bit. And really more appropriate for a probate presentation, which we can, I hope we'll have. Because the question is that it kind of depends less on the type of bill and more on what funds are available. So stay tuned for a more detailed answer on that as well. Somebody's asking, and he says, hopefully a simple question, which of course it never really is, but can you share what states either accept a Georgia will or do not accept a Georgia will? And the answer to that is less about accepting a Georgia specific will and more about what language is in your Georgia will. So we try to draft our documents certainly so that they cover Georgia law, but that they could apply in other states as well. But of course, I don't know Florida law because it's crazy. Florida probate's very different from Georgia. So I can't guarantee that my Georgia will is going to work in Florida. But it's not that a Florida court is not going to accept a Georgia will because it's from Georgia. It's more about the language that's in the will. Okay, somebody else asked, this is a great question. If you have your husband listed as a beneficiary on life insurance and retirement accounts, but both husband and wife die in a car accident, can you list your kids as backup beneficiaries on the same form? Yes, and you should, right? So you should have backup beneficiaries in place on all of your beneficiary designated accounts. Absolutely. A caveat and a really important point there is that if you have minor children or folks with special needs, you can list the trust for those people as a beneficiary of a retirement account. And especially if those of you that saw, not to toot our horn too much, but those of you that saw our newsletter, there's been some changes in the way retirement accounts are distributed to beneficiaries through the Secure Act. And the special needs trust can be a really useful tool in maximizing your retirement account. So beneficiary designations are really important to stay on top of. You should absolutely have a primary beneficiary, likely a spouse or somebody else who's, number one, and then you have a backup. Somebody else asked, going back to the will and asking about, is the executor and the personal representative the same job? And the answer is yes. Those are interchangeable. The only caveat there is an administrator of an estate when you don't have a will is also a personal representative. So it's just a slightly less specific term. Somebody else asked, is it best to have a revocable living trust if a beneficiary has special needs? And that just depends. That depends a lot on your circumstances. I want to be very clear. If you're trying to leave any funds for a person with special needs, you almost always want to do a special needs trust. I may have misunderstood your question. You yourself can do planning via a trust or a will, but you always want to leave funds to a person with disabilities through a special needs trust. Almost always. That's a pretty solid rule. And let's see. Somebody else asked about So first of all, you asked, is it customary for an executor of a trust to be compensated? So you would have a trustee of a trust who's managing the money, and you have an executor of an estate. In either case, it depends. I hate to say that so much, but it does. It depends on the circumstances. Under the law, an executor or a trustee can take a fee for their work because it usually is work, and there's an allocated amount under the law for the fees for an executor or a trustee. You can also specify in your documents, hey, I want to pay this person so much money. It's not necessarily customary to do that, but it's something you can consider. That's something that totally depends on your circumstances, because sometimes I say, you know, we don't need to add more money to this child who's serving as your trustee or your executor, because that might make it kind of inequitable and we might have some other family issues. But sometimes it's a great idea to provide payment. It just depends. Let's see, I was gonna look, there was a couple other, somebody asked the difference between common and solemn form probate, and that again is really a question of more of a probate, because it's a little bit complicated. But common form and solemn form, when you're filing a petition to probate, you're getting different powers for being able to act depending on what you file. Typically you want to file solemn form, very rarely that you want to file common form. Okay, and then someone asked us to ballpark the relative cost of a simple will with trust, which I don't mean to give this person a hard time, but we have people call all the time and ask about a simple will with a trust, which is usually not quite as simple as one might think. But I can ballpark it, and it just, frankly, our fees totally depend on the circumstances. But when we're talking about basic estate planning for folks with doing kind of a will and powers of attorney, that for an individual, that starts around, well, let me see, we've got a fee sheet. Let me just give it to you straight. So it starts around $1,400 for an individual, and it goes up from there. And it just totally depends on your circumstances. Lastly, someone else asked, will this recording be available? And I believe it will be available for a period of time on our website. And of course, we're always available for questions. You can go onto our website, which is nadlerbiernath.com, to get a lot more information about a lot of these things that we've talked about. And you can also feel free to contact our office with further questions or to see about setting up an appointment, things like that. Let's see, we've got just a few other questions come in. Oh, someone asked, is our only location in Peachtree Corners? And yes, that's the case. However, right now we are not seeing clients in person. We are in our office, as you can see, I'm here, but we are not seeing clients in person. We're doing phone conferences and Zoom conferences, and we're happy to do that. And we're doing signings in the office, but that's really it. So frankly, we're kind of lucky that we can have all of these technology options, and hopefully we can help people all over Georgia. And so with that, there are a couple other questions, but they're very specific. So what I would suggest you do, and also for the couple of people that ask for referrals, is send our office an email. We'll be happy to give you those pieces of information. And I hope everybody has a great rest of the day.